Half of Oklahoma is a reservation. The United States government drew that boundary in 1832, and for 113 years, the state of Oklahoma prosecuted crimes, collected taxes, and exercised jurisdiction over land that, under federal law, it had no legal authority to touch. This is not a historical footnote. In 2020, the Supreme Court of the United States confirmed it. And in doing so, they did not create a new legal reality. They uncovered an old one. This is Case File 002. We're going to map it. At the center of this map is a man you should not feel sorry for. What the Supreme Court had to do with his case is what changed the map. I want to tell you about the Muscogee Nation, not the history, not the culture, but the legal document. In 1830, the United States Congress passed the Indian Removal Act. It authorized the forced relocation of the 5 civilized tribes, the Cherokee, Chickasaw, Choctaw, Creek, and Seminole, from their ancestral lands in the American Southeast to what was then called Indian Territory. That territory was not a reservation in the way most people understand the word. It was a sovereign nation, a permanent homeland. The word used in the treaties was permanent. The Creek Nation, formerly the Muscogee Nation, received a specific tract, approximately 3.25 million acres, in what is now eastern Oklahoma. The boundary was surveyed, the deed was signed, the coordinates were recorded. What happened next took 113 years to formally correct. This is the part where I need to explain the 1832 Treaty of Cession. On March 24, 1832, the United States signed a treaty with the Creek Nation. Article 14 of that treaty defined the specific boundaries of Creek territory in Indian Territory, not approximate boundaries, surveyed boundaries, recorded boundaries. Under that treaty, the Creek Nation ceded their lands east of the Mississippi River. In exchange, the United States promised them 5 million acres west of the Mississippi in perpetuity. The treaty established a specific jurisdictional protection. The Creek territory would be theirs as long as they occupied it. No state government would have jurisdiction. No state court would have authority. The land was Indian Territory, and Indian Territory fell under federal jurisdiction exclusively. In 1856, a second treaty refined the internal boundaries. In 1866, after the Civil War, a third treaty was signed. The Creek Nation had fought on both sides of the conflict. The 1866 treaty restructured internal governance, but preserved the foundational promise. The land was theirs. The federal protection held. The boundary remained. By 1907, Oklahoma achieved statehood. No treaty was formally abrogated. No congressional act formally dissolved the Creek Reservation. No document exists on record in the congressional archives that reads, "The Creek Reservation is hereby dissolved." Oklahoma simply proceeded as though it had been. This is the part where I need to explain the Major Crimes Act. In 1885, Congress passed a law that changed the jurisdictional architecture of every reservation in the United States. Under 18 U.S.C. Section 1153, the federal government, not state governments, has exclusive jurisdiction over specific major crimes committed by Native Americans on reservation land. The list is explicit: murder, manslaughter, rape, sexual abuse, kidnapping, arson, burglary. Under that statute, if you are a Native American and you commit one of those crimes on reservation land, the state cannot prosecute you. No state detective, no state prosecutor, no state court, only the federal government. This is not a loophole. This is not an ambiguity. This is a 140-year-old federal statute that was sitting in plain view the entire time. The question in McGirt versus Oklahoma was not whether 18 U.S.C. Section 1153 applied. The question was whether the land it applied to, the Creek Reservation, still legally existed. We build these maps one case file at a time. Every overlooked legal boundary, every treaty that is still technically in force, every jurisdictional gap the official record does not explain. If that investigation is what you came here for, subscribe. New files go up weekly. In 1997, Jim C. McGirt was convicted of 3 counts of sexual abuse against a 4-year-old child in Wagoner County, Oklahoma. The crime occurred in Broken Arrow. He was sentenced to 2 500-year sentences and life without parole in state prison. 23 years later, he filed a challenge on a single legal ground. He was a registered member of the Seminole Nation of Oklahoma. The crime had occurred on land that, if the Creek Reservation still legally existed, fell under federal jurisdiction. If it fell under federal jurisdiction, the state of Oklahoma had no authority to try him. Before I explain what the court found, found, you need to understand what disestablishment means. For a federal reservation to lose its legal status, Congress must formally dissolve it. The Supreme Court has been consistent on this point across more than a century of precedent. Disestablishment is not implied. It is not inferred from population change or state governance or the passage of time. It requires a specific congressional act, explicit language, clear intent. Oklahoma argued that the Creek Reservation had been effectively dissolved through a series of allotment acts, the 19065 Five Tribes Act, and over a century of uninterrupted state governance. The Supreme Court read every document Oklahoma cited. They found none of them said what Oklahoma claimed. Justice Neil Gorsuch wrote the majority opinion. He wrote it in language that does not leave interpretive room. On the far end of the Trail of Tears was a promise. Forced to leave their ancestral lands in Georgia and Alabama, the Creek Nation was promised a reservation in perpetuity. Congress has not said otherwise. We hold the government to its word. The court held 5-4 that the historical record contained no congressional act that formally disestablished the Creek Reservation. Allotment had changed how the land was held, broken from tribal ownership into individual parcels. Statehood had changed who lived on it, but the reservation, in federal law, had never been dissolved. It still existed. It had existed continuously and legally since 1832. 4 justices dissented: Roberts, Alito, Kavanaugh, Thomas. They warned the ruling would create administrative chaos. Thousands of state convictions exposed to appeal. Tax authority unsettled. Civil regulation unsettled. They argued that the practical consequences should weigh against the textual reading. The majority answered that practical consequences cannot dissolve a treaty. Only Congress can dissolve a treaty. Congress had not. The immediate consequence was procedurally precise. Oklahoma had no jurisdiction to prosecute Jim C. McGirt. His state conviction was vacated. The federal government would need to retry him under its own authority. The secondary consequence was larger than most people understood on July 9, 2020. Oklahoma has approximately 4 million residents. The Creek Reservation, as confirmed by the 2020 ruling, covers the eastern half of the state, including Tulsa, including its surrounding suburbs, including communities that have functioned under state jurisdiction since before anyone living there was born. Approximately 1.8 million people live on what is, in federal law, reservation land. 1.8 million people, none of them new. Most of them are not Native American. Under 18 U.S.C. Section 1153, the Major Crimes Act applies only to crimes committed by Native Americans on reservation land. A non-Native American committing a crime on reservation land remains subject to state jurisdiction, but crimes committed by Native Americans on this land now fell exclusively under federal authority. No state investigation, no state prosecution, no state sentencing. The Oklahoma state court system had been processing these cases for 113 years. Hundreds of criminal convictions were immediately subject to appeal. Defendants, who had been prosecuted by Oklahoma state courts, argued correctly under the ruling that those courts had lacked jurisdiction from the beginning. Some were violent offenders. Some had served decades of their sentences. The question of what to do with those convictions was not resolved in the McGirt ruling. It was left on the map. 2 years after McGirt, the Supreme Court returned to the same territory. The case was Oklahoma versus Castro-Huerta. Victor Castro-Huerta was a non-Native American convicted by an Oklahoma state court of child neglect. The victim was a member of the Cherokee Nation. The crime had occurred on reservation land. McGirt had established that Oklahoma lacked jurisdiction over crimes committed by Native Americans on reservation land. Castro-Huerta tested the inverse. Did states retain concurrent jurisdiction to prosecute non-Indians who commit crimes against Indians on reservations? Oklahoma said yes. The Supreme Court agreed. 5-4. Justice Gorsuch dissented. He wrote that the majority had rewritten a century of federal Indian law without textual basis, that the decision produced a jurisdictional framework that existed nowhere in statute, nowhere in treaty, and nowhere in prior court precedent. The same court that had confirmed the reservation in 2020 had, 2 years later, hollowed out what confirmation meant. And here is what Castro-Huerta did not do. It did not dissolve the Creek Reservation. It did not overturn McGirt. It did not restore Oklahoma's jurisdiction over crimes committed by Native Americans on reservation land. The reservation, confirmed in 2020, remains confirmed. The boundary drawn in 1832 is still on the map. What changed is who administers it, and for which defendants and in which circumstances, depending on the identity of the accused and the identity of the victim and the specific nature of the charge. No single agency holds total authority. No single court holds exclusive jurisdiction over every case. The legal map of Oklahoma is not what most Oklahomans believe it is, and no one has finished drawing it. The 1832 treaty is still in force. The reservation it created is still legally intact. The state of Oklahoma spent 113 years exercising authority over land where that authority was, at minimum, legally contested. The Supreme Court did not manufacture that reality in 2020. They read the documents. McGirt was retried by federal. The reservation is still there. The jurisdictional question is still being litigated, case by case, county by county, in federal and state courtrooms across eastern Oklahoma. The promise was made in 1832. The court confirmed it in 2020. The map has not changed. Every case file lives in the playlist below, documented, mapped, on the record. If you want the next investigation the moment it goes up, subscribe. We post weekly. Case file 002 is already open. There are more maps that do not say what people think they say.